Hey everyone. First and foremost, I know a lot of you don't like the talkie videos as much. So I'm going to start a second channel where I'm going to put most of the commentary channels because the algorithm's got mixed emotions on running both at the same time. And I'm going to keep Meg's Crime Watch mostly court hearings. So it probably should have been Meg's Court Watch, but I don't think I can change the name this late in the game, can I? Anyways, so take a minute and subscribe to the new channel. I don't know what the name's going to be yet, but hopefully it's a good one. And if you're watching from the new channel and you enjoy the court hearings, subscribe to Meg's Crime Watch. Hey everyone. For anyone who missed it, yesterday was wild. There was crazy going down in courtrooms across this country. It wasn't even a full moon. I checked. It wasn't even anything special. There was no reason for it. It was just a crazy, wild day in court. I'm going to give you a quick look before we jump into the main event. Started in Judge Glanville in Fulton County. The YSL trial, apparently, the prosecutor and a witness met with Judge Glanville in an ex parte meeting, and the defense attorneys found out about it. Judge Glanville wants to know who told you. The defense attorney says, "Can't tell ya. Sorry, I'm not stitching." Whew, that didn't go over well. Check this out.
Tell me who this information was
I don't want to
come
be
from.
held in contempt.
Well,
I'm not
then
answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am telling
tell you
you-
what. I'm going to give you 5 minutes. If you don't tell me,
don't
who
have
it is,
to. I'm
if
gonna
you don't tell me
continue.
who it is, I'm going to put you. In,
But
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
go to
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I am not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland,
recess.
Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Well, I just had a little flashback to my parents yelling at me. You got 5 minutes to confess to what you did. 5 minutes to think about it. I'm coming back in 5 minutes. You better tell me. Oof. You think he tells him?
Okay, Mr. Steele, would you take the podium, please, sir? All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just. Interrupt you.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raise it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're
but
saying,
see,
you're threatening me with
the
contempt. Just
privilege
listen
would
to this.
occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going
Sir,
to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in
Don't
time.
you, Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk
well,
about
then you'll be in custody until then, because because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well, then, other than
Answer
if
that
you were
on the
sitting,
attorney-client.
unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got
I'm
this
not gonna have any
information-
further- I'm not going to have any further. Yes, sir. You certainly may.
So the biggest thing I think that the defense attorney is trying to say, I could be totally wrong, but if he got that information from his client or something along those lines, he can't divulge that information because that's protected by his attorney-client privilege. I'm not positive, but I felt like that was where he was going with the rule he was trying to cite. I don't know. They mentioned eavesdropping and everything else. I just know that this has been such a contentious hearing between the attorneys and the judge, and this is not the first blow up, and I know it's not going to be the last. So 5 o'clock rolls around, and this is what happens.
Mr. Williams does not wish to go forward without me being here. You are removing me from my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Oh. It makes sense, the judge wanting to know, like, where did you get this information from? Because obviously there's an issue. You shouldn't have had this information until I decided to, make you aware of what had happened. But at the same time, there are ethical obligations on the other side of this. So 6 of one, half a dozen of the other? I'm not sure. Wow. So then up in Boston, Trooper Proctor, who was the lead investigator in the Karen Reed hitting her boyfriend with the backing up into him with the SUV allegedly murder trial, he's friends with and related to half of the Northeast, and sent some text messages to his friends all over the place talking about everything that's been going on. It's very ethical and yeah.
Now, do you see a response toward the bottom of the page from yourself, January 29th, 2022 at 11:04 p.m.?
Yes.
And can you read that response for the jury?
Yeah, but there'll be some serious charges brought on the girl.
And what did you mean by that, sir?
That throughout the course of the day, we had compelling evidence that Miss Reed struck Mr. O'Keefe with her vehicle.
And you have two responses from friends, the same friends, at the bottom of that page, 2537, is that correct?
That's correct.
And what are those responses?
Keep your voice up loud, please, Trooper Proctor. Jurors can't hear you.
Yes, Your Honor. Number ending in 5051. Got to be. I could only imagine what internal affairs of the BPD are trying to get out there. And the second response, same number. She hot at least.
And turning your attention to the next page, 2538, at the top, if you could just read a series of responses from yourself, correct?
Yes, sir.
Read from those, sir.
Yep, so these came from me. From all accounts, he didn't do anything wrong. She's a whack job. CUNT.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Yeah, you probably shouldn't have done that. And for those of you who missed it, the bachelor, Clayton Eckerd, finally got his day in court to face his accuser, who over a year ago accused him of fathering twins that he felt like he couldn't possibly have fathered because there's certain things that are required to make that happen. And his attorney made himself legendary in my book with the following line of questions.
Caption at the top. I think it says, the final opportunity to consider abortion. You remember getting this from Laura?
Yes.
Move to Admit Exhibit 7. Clayton, and this will get awkward, but further down in that email on July 1st, which was weeks after the alleged encounter, Laura references her tight vagina. Why is that both uncomfortable and relevant to court today?
Because she's stating that if I would have felt how tight her vagina was, I might change my mind, which is her stating that I never penetrated her. We never had penetrative sex.
Wait, the exhibit that the court just received has Laura saying that her vagina was tight as if you hadn't been in there before?
That is correct.
Well, had you been in there before?
I had not, no.
Good morning. I'm Dr. Kim.
Had you been in there before? And that right there just clinched the whole trial. Had you been in there before? No? Oh, this is the proof? Okay, that's all we needed to know. Now, here is a colorful press conference on a very important subject with a very important meaning, and like, I strongly support the purpose, but the delivery had me giggling. I can't lie.
Good morning. I'm Dr. Candace Matthews. I am the National Minister of Politics for the New Black Panther Nation, here standing with my chairman, Brother Cornel X. We're here in reference to an atrocity that has happened here at this elementary school that stands behind us by the name of Gray Elementary, that is in the school district of Lamar Consolidated ISD. We have a former music teacher that was here this school year when this shocking video has happened. This school teacher that was a music teacher taught several grade levels here in this school. We have shocking video of this music teacher doing porn videos in the music classroom, and also a second video of her doing this porn video in the school bathroom during school hours. So, and let's not leave out, she also had her school ID badge on. I called also to verify was this teacher still employed here at this school. So it comes to find out that the teacher is no longer employed here, but not for this incident. The administration had no idea of the videos that was taking place here in this school. So what we are demanding that Lamar Consolidated ISD need to get with the Texas Education Agency to let them know about this atrocity of what has happened with this teacher, because this is how demented teachers go from one district to the next, jumping from district to district without, they can go and apply for a job and they have their teacher certification, they don't have a criminal record, but you over here doing explicit activities in an elementary school. That is unacceptable. So that's why we are calling this out. We are not going to sweep this under the rug. I did speak with administration here at the school district. They were not aware of that. However, they did wanted to share with me, like I did let them know that I was going to bring this public. They did not want me, to bring it public because they did not want, the community to feel like they wasn't doing their job. But how can you not say that you're not doing your job because you didn't know anything about the video? Now that you know about the video, now we expect for you to do your job. We expect for you to go to the Texas Education Agency. We expect for you to put a block on this teacher so this teacher cannot go to another school and do this type of foolishness. This can be the same type of teacher that can touch a child. If you taking your clothes off, you're smacking your behind, you're flapping your breasts out and gyrating yourself in a classroom where students are during the school day, and you're doing this in the bathroom, that is unacceptable.
OMG.
So basically I'm gonna let Brother
Tell us what
Cornell
she
state
did.
his piece and then I'll close it out.
You really can't make this stuff up.
No, you can't.
It is absolutely appalling, shameful, and frightening that these are the type of educators that are in an elementary school teaching our children. When parents send their children to school, they believe their teachers are people of the utmost highest character. But now we got a teacher in the classroom on school hours, stripping down butt naked, bending over and showing everything on the video, and all you could see was cellulite hanging in pubic hair. This is a disgrace and a shame that this is the type of educator and teacher that is in the classroom. And she made multiple videos. Yes, the district was unaware until we brought this to their attention. But what we're asking you to do now is to go even further. Nullifying her contract is not enough. We demand that the superintendent and the board ban her from ever teaching in this school district again. We want a permanent ban on her. Secondly, we demand that this school district send a letter to TEA demanding her certification as a teacher be terminated and revoked. 3, we're demanding that this district contact law enforcement, and we want to make sure that the students that she taught are interviewed, or a hotline is set up to make sure that she knows things in the classroom that may be inappropriate, unethical, unprofessional, or dangerous in the environment of those children. If she would do this in the classroom, what else will she do? This woman obviously had lost her damn mind. She needs psychotropic medication. She pulls out her breasts and she's juggling them. Look like she's about to fall over. Then she bends over and pulls down her panties.
I need to see this
Spreads her cheeks. I'm not lying. I'm telling you what's on the video. Spreads her cheeks.
We don't need to know that.
This is madness.
Yes.
This woman should never, ever be allowed to be an educator. This woman should never be allowed to work around children ever again. And I believe that if a thorough investigation takes place, you can find something criminally to bring her into a courtroom for. Because I've seen law enforcement put parents in courtrooms for far much less than this. If we can put Donald Trump in the courtroom and find something to prosecute him for, don't tell me we can't find something to prosecute this woman for. This is sad.
Lord.
This is madness. This is filth at its finest.
I don't think that's
And
the
so
same
we're
thing.
praying that the school district, we're not attacking you. You didn't know anything about this lady. But now that you do know, show the aggressive, proactive steps that you will take to make sure she never re-enters a classroom.
From what I was told is that she's looking for employment with other school districts. So that's why this is imperative that we amplify this issue, because this is how you have demented teachers going from one district to the next doing this type of behavior. So I just want to send a message out to her, because see, that video was so horrific and appalling. We just want her to know that her retired porn star activities is done. Okay? You're done. You would never let set foot in now one of these classrooms. You would not even have the opportunity to disgrace our eyes with that foolishness that you did in that video. So your porn days is over. And also your teaching days. We're done with this. So we demand the school district, please, again, we're not here to attack you. We're here to inform you of what you had in your school. And this is where you can prove to your the parents and the constituents that you are going to be zero tolerance when it comes to this type of stuff and these type of deviant individuals doing this in this classroom amongst our babies. That's unacceptable.
We want to make sure that if she wants to be a porn star, and it's obvious she does, that's her business.
Baby, she retired.
But we want to make sure that she never teaches in a classroom again, that her teaching certification is revoked, and she never has the opportunity or access to children again. If she wants to teach, if she wants to be a porn star, based on what I saw in that video,
Baby, she retired.
I don't think she's gonna make a lot of money. Based on what I saw in that video, I don't think she's gonna be at a top tier status. That's a damn shame what I saw in that video. That's sickness. And I think that this woman needs to be mentally evaluated by a therapist.
Absolutely.
But let's make sure the school district protects the state of Texas children, so she can't run from one district to another seeking employment, because it's not in her personnel file what she was terminated for or why she's banned from the district, because they've already didn't renew her contract for other reasons. Well, that won't stop her from being employed somewhere else. But if they put in there that she's banned and they want to know why she's banned, it's done. In fact, most school districts won't even ask. Once they see you're banned, you won't be hired. Any more questions?
It appears it was related to some kind of electronic.
That's a lot to digest. I'm not sure we needed that level of detail on what was in the video. I think just the fact of what it was and that it was filmed in a school was sufficient. That's pretty bad that she filmed it in a school. It's even worse that she filmed it in the school while children were there. I just don't even know what to say to all that. Those two are yeah, we're just gonna get into it. So there's some follow-up to this, and yeah, let me just show that to you.
I spoke with the woman who did not want to be identified. She tells me she regrets taking that video for her ex-boyfriend's pleasure and is now claiming to be a victim of revenge porn.
I made some poor decisions throughout my relationship, and it's now come back and haunting me.
She did admit to taking the sexually explicit video while at school to send to her boyfriend at the time, but says he exposed her because she no longer wanted to stay in the relationship and financially support him.
He said, okay, you want to go down this route? I will send you out any pictures or videos that you had sent to me to the school.
And the woman had words for both Quanell X and Dr. Candace Matthews.
I'm disappointed that with one story, you decided that you wanted to let a man ruin my life. No one should ever judge a person based off of a mistake. No one should ever assume that because I did this, because it was meant for one person, that defies the person that I am.
While the original story went viral, the follow-up with the clarification didn't really make many headlines. The Houston Chronicle did cover it, and They let people know that the ex-boyfriend was in fact charged and accused of leaking the videos of the Lamar CSID teacher. Nicholas Anthony Garcia, 29, was charged with unlawful disclosure of intimate visual material, according to these documents. Just so you know, this is out of Harris County, Texas. We're familiar with Harris County. We've been there quite a few times in our videos. They're not naming the former teacher because she has not committed a crime. She did admit last week to taking the videos of herself in the classroom to send to her now ex-boyfriend. According to Fox 26 Houston, the school district issued the following statement. This afternoon, the district received copies of 2 videos of a former employee allegedly recorded on school property. The videos were provided by a citizen. Our officers have opened an investigation and, upon initial review, we do not believe that children were present during the filming of the videos. However, the investigating officer is working to verify the timestamp and circumstances surrounding the videos. If the district finds that the criminal behavior or conduct violating the Texas Administrative Code Educators Code of Ethics has occurred, we will engage with the appropriate reporting agencies. She's probably not going to be able to teach again in Texas, but I don't think there's going to be criminal charges unless she was stupid enough to do this with kids there. In a now deleted tweet, Governor Greg Abbott's put up a link to the original story and said, any parent of a child in a school like this should have the right to choose a school that's best for their child. Yeah, like the school had anything to do with this and could have foreseen this happening. Yeah. Anyways, so now you know the whole story. And that's the truth. I'll see you next time.